Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast hosts, we try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this podcast helpful, as always, please send it to a colleague.
Yeah, and if it's unhelpful, send it to your opposing counsel. And a quick announcement, our podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and now has a new product called Co-Counsel, which will prepare legal research memos, summarize exhibits, and provide a variety of AI-backed activities. It's definitely worth checking out. And listeners to our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Yeah, if you haven't checked out Co-Counsel yet, look it up on Google. Watch they were on Morning Joe a couple of weeks ago demoing the product. It really is revolutionary. It's going to change the way you deploy your staff and other resources. All right. Well, Jeff, so far in our survey of other states' rules and procedures, we've compared California with Illinois and Utah and Florida. And we've learned that we learned so far that California is in the minority of other states in letting the legislature dictate rules of civil procedure. But we've also learned that not all states afford a constitutional right to a reasoned opinion like California does. So there are real differences, pros and cons of different states. And today we continue our survey. And in that mission, we are pleased to welcome Minnesota appellate attorney Jeff Markowitz. Jeff is a relentlessly creative appellate advocate. He clerked for the Minnesota Court of Appeals for over 2 years. He taught appellate advocacy to law students. He co-chairs his firm's appellate practice group, and he frequently appears on appeals. His appellate experience includes appeals involving the Minnesota Court of Appeals, the Minnesota Supreme Court, Minnesota Workers' Comp Court of Appeals, the North Dakota Supreme Court, Wisconsin Appellate Courts, and the United States Supreme Court. Jeff Markowitz, welcome to the podcast. Thanks for joining us.
It's good to be here. Thanks for having me.
Yeah, now, Jeff, everything I know about Minnesota comes from the movie Fargo. So I'm looking forward to learning a little bit more about Minnesota beyond those four corners of that movie.
The movie's exactly right. There's nothing more to talk about.
All right, interview's over.
Well, I've got to ask you, Jeff, fill in the blanks of what I didn't talk about during your bio, and make sure that it wends around to your experience in the United States Supreme Court. You've got to drop that knowledge on us.
Sure. So I love appellate work. I genuinely do. I'll start with the end of the question, though. I have successfully opposed two petitions for writ of certiorari, although one of them recently did seem like it was almost going to be granted. And I'll say, as a side note, as an appellate lawyer, you always you advance your client's interests, and that you keep that number one. But a consolation prize of losing an opposition to a petition for a writ of certiorari to the U.S. Supreme Court is you get to go to the U.S. Supreme Court. We did not get that consolation prize. We got the main prize, which was denial, but the court did seem interested in the petition. This was a medical marijuana issue that intersected with the Minnesota workers' compensation system, where a person who was participating in the Minnesota medical marijuana program was taking marijuana, buying it from a state legal facility, and sought coverage from his workers' compensation insurer. The insurer said, no, I won't cover that federally illegal Schedule I substance. And there was litigation over it. And the big issue was preemption. Did federal law, primarily through the Federal Controlled Substances Act, preempt Minnesota law from requiring a workers' compensation insurer or employer for reimbursing? And we got a yes from the Minnesota Supreme Court in a 6-1 decision. The states are split on the issue. It depends how you count. I think at one point it was arguably roughly 3-3, but it's a little difficult to count it. My numbers might be old, but there's a split. And the employee filed a petition with the U.S. Supreme Court for review, And the Minnesota Supreme Court requested the opinion of the U.S. Solicitor General's office as to what the Solicitor General thought of the matter, which often is a sign that the court is interested in taking an appeal. And the Solicitor General said, we agree with the Minnesota Supreme Court, do not take the appeal. And that was consistent with our position, and the court denied the petition. So, but that was I would say a pretty close call. And I had one other one that was a Section 1983 issue that dealt with a heck issue, which I would struggle to really pull out and speak confidently about it today. But it was another successful opposition. So, yay us, we won, but we did not get the consolation prize that appellate lawyers enjoy, which is getting to go to the U.S. Supreme Court.
That's right. That's right. When you successfully make the Supreme Court uninterested in your case, then you don't get the further benefit of appearing in front of the Supreme Court. So are those cases indicative of your practice? Or were they more one-offs? My one almost shot to the Supreme Court was very much off the beaten path for the rest of my practice. It was an EEOC case. The rest of my litigation is business business disputes. Not civil rights disputes like this one was. But what about your bread and butter cases, your day-to-day practice?
I spend more than 50% of my time on appeal, and it gives me no end of joy to get to say that. I am at a firm that really sees litigation as a team sport. A lot of my colleagues call themselves trial lawyers, and some of them mean by that, I do not want to go on appeal. And they are happy to have someone who says, I want to be on appeal. I also enjoy the trial work, but I want to go on appeal. And so we have a really good system where myself and several others in our appellate practice group will partner with the trial lawyers, but that often looks like we're taking the lead. The trial lawyer says, here's the case, here's what happened, take it from here, let me know if you want to chat about anything. And I spend more than 50% of my time at any given time during the year, sometimes as much as 70 or 80%, doing appellate work, which is the straight up briefing. It also can include amicus briefs, which are super fun. I do a fair number of those, and I can safely say it's been years now since I was not on appeal on at least one issue at any given time, including at the Minnesota Supreme Court. I enjoy it very much.
Yeah. How do you get approached to do amicus briefs?
So it's been different ways. I actually had a former law school legal writing professor who knew I liked appellate work and had seen me on appeal once I got into practice. And he said, I have a client that needs amicus support from Association X. I communicated with the association, and I was hired there. So that's one way. Other times it's with, I actually do a fair amount of work with the Minnesota Defense Lawyers Association. One time I actually spotted an issue that it was in a non-precedential, unpublished Court of Appeals opinion, but it was one of those lines that really looks like nitro booster for a petition for review being granted by the Minnesota Supreme Court. Yeah. And so I reached out, and from there now there's a bit of I'm in a group of people who do a fair amount of that amicus work. But I'll also say, though, I mean, I do a lot of defense work, but I would say the amicus work I've enjoyed most recently has been 2 joint amicus briefs that MDLA, the Minnesota Defense Lawyers Association, has done in partnership with a plaintiff side association, the Minnesota Association for Justice. So there were 2 separate emails in the past 2 years appeals in the past 2 years or so that we jointly agreed on something. We often disagree. Of course, we often disagree. These are different organizations on different sides of the V. One of them was on the common interest doctrine to the attorney-client privilege and whether Minnesota should recognize it. The Minnesota Court of Appeals said we don't have the authority to recognize it. We're just an intermediary court, and we're not doing that here. And the whole world woke up for that one. So it wasn't just our organizations, but others. And the Minnesota Supreme Court recently recognized the doctrine. Another one, though, that's happened more recently, and it's currently on appeal, is an issue of litigation finance. It deals with these financiers who will provide financing for plaintiffs, often in the middle of the case, sometimes at the outset, big and small, in order to help them make ends meet, whatever that means.
That's very much an emerging industry. I think, 5-10 years ago, certainly, I don't think you'd find maybe one or two of those companies. Now they're all over the place.
Multi-billion-dollar industry, and it touches everyone from Jane Smith, personal injury plaintiff who needs $6,000 to pay some living expenses, and it touches on larger players. There is currently a high-profile litigation finance dispute happening right now between Cisco Foods and Burford Financial and some of its subsidiaries.
Oh, yeah.
An arbitration panel in a 2-1 decision granted the litigation financier a settlement injunction prohibiting Cisco from entering into 2 proposed settlement agreements in antitrust litigation. And the dissenter said, but they don't want to litigate anymore. You're now requiring them to go litigate when they want to stop. And
that's the huge fear, is that the financier is going to drive the litigation decisions.
And what do you know? We the enemy of my enemy sometimes can be my friend. And the plaintiff's bar can be concerned about those abuses in the background, and the defense bar doesn't want to be litigating cases and having the whole settlement calculus broken because these financiers are puppeteering behind the scenes. I know this is a controversial topic. The financiers say, we don't control the litigation. We don't control the litigation. We don't control the litigation. In this case, the contract actually has a consent provision, this Cisco one. But sometimes they don't. It's hard to know whether they do. These aren't often disclosed. But a part of it is just some of these terms. You have to. They'll include things like you must prosecute the claims in good prosecute the claims in good faith, or you can't settle in. And you can't settle in bad faith, terms along those lines, which just make it sound like if it's a breach to settle and you're not happy with us, that means litigation. That could have a chilling effect. So anyway, that's a whole side note. But I really enjoy those partnerships where you find like we disagree on a lot, but we come together and agree. And I've enjoyed that about these cases.
Yeah. And I know you, I think we met on LinkedIn, and I know you're plugged in on LinkedIn there. And you talked about how, you stay plugged in through, your alumni association, through former law professors. So people, you are involved in other circles who know your passion and your skill for appeals. And so you get work that way. I wanted to ask you something about what you had in your bio on your website that I really liked. And I'm going to read it here. So this is from Jeffrey Markowitz's bio on his website. Are you involved in an appeal? Jeff would love to lead your charge or be a second set of eyes to help make things right or defend the win. Are you wrestling with a knotty appellate question? Call Jeff. He'd love to help you get it untangled. Would you like help preparing for oral argument, possibly through a moot court or practice argument? He would love to guest judge or otherwise be your sounding board, end quote. Now, I wanted to ask you about the first bit, Jeff, where you say that, are you involved in appeal? He'd love to lead your charge or be a second set of eyes, because when the trial attorney would prefer to lead the charge himself or herself on appeal and just have the appellate attorney as a second set of eyes, I wanted to ask your opinion if that structure works well, because I say something similar. I like the way you put it here, but I'll make a similar pitch, and I have my own pros and cons to that. But I'd be interested in hearing your take on it.
I think that appellate lawyers, among other hats they have to wear the hat of helper. There are going to be some times where it's like some of my colleagues will say, I'm a trial lawyer. I don't want the appeal. I trust you. Keep me in the loop, but you can run with this. But there's going to be other times someone's going to understandably say, I lived this case. If there was a trial, I tried this case. And the notion of me just letting go of the reins and having someone gallop away and just maybe check in from time to time doesn't feel right. And so I would say most of the time, the people who send me appellate work are happy to do you just go run with it approach. But I'm certainly happy, and there's one person in particular I'm thinking of. Sometimes they like to be really involved. They want it to be a partnership, and I'm certainly happy to make that happen. I even think I think having an appellate lawyer even in before the case comes to judgment can be valuable. But even if it's just as no earlier than the moot argument. Do a practice argument before you go to that appellate panel. You see the briefing is in, and there's still a lot of horses are out the gate at that point. But at the very least, bring in someone who thinks like the appellate lawyer thinks, who's used to that world, who's used to managing 15 minutes or whatever the appellate court's time limit is, and could help you there. So I'm happy to do the as little bit as needed, but I often find that I'm trusted with a lot more because that division of labor makes sense, and you need that person who didn't live the record. I actually had a case. I've had one case where I thought, it was a big case. I was heavily invested in it, and I thought, if this goes to appeal, I can't drive that because I am too darn close to this thing. I was lead on discovery. I would have been lead at trial, and it just it changes the way you think. The appellate lawyer comes into that cold record, does not know the drama, does not hear the emotion, and just sees this is what the transcript says, this is what the briefs say. And I think that's just so valuable. And I recognize I can't do that for me. As I had a colleague who I had already talked to. I said, you're going to be the guy. And he agreed he'd be the guy leading it. And I would be there. I would be helping. But I think he would need to be the one making the tough calls because I'm tainted. I recognize because of,
Yeah, exactly right. Yeah, I say something similar that, when someone asks, well, why shouldn't the trial attorney handle the appeal? The trial attorney was at the trial. You weren't there. How do you know? I say, yeah, you're right. I wasn't at the trial. I didn't have a front row seat at the witnesses when I didn't get to see the glistening of the sweat on the witness's brow when he was lying through his teeth. And I didn't see the jurors roll their eyes or the judge, guffaw. But who else didn't see that? The appellate bench didn't see that. So I'm better situated than the trial attorney to converse with the appellate bench because I don't have that front row experience.
Bingo. For any trial lawyer who's ever taken a deposition and thought they got some great admission or there was some horrible bombshell that was dropped and then they got the transcript and they realized they were wrong, that's the quintessential thing that happens with the appellate record. You live it and you have all these trappings and these feelings and that are attached to it. And you even may have heard something a certain way and maybe the other side heard it the same way, but that's not what came across in the cold written record. And the appellate lawyer can see that. The outsider can see that. And that's what the judges are going to be deciding your appeal can see.
Yeah, exactly right. All right. Let me ask you, I want to ask you something else about you have you're an avid strategy game player. Can you tell us about that? Because I know our Jeff Lewis is a strategy game player. What do you mean by what kind of strategy games?
Strategy games are my happy place. I could be coming off of an exhausting, stressful, brain-churning month, and I will be relaxed by playing a game of Settlers of Catan or Small World or Pandemic or Coup. Just listing things off to see if any of the listeners are my people. For anyone out there, if one of your happiest game playing moments of your life was Pandemic Season 1, you are my people. So I have a wife who loves those games as well. Unfortunately, we're now adults. We have a kid. We have a second one coming, and other friends are like that too. And it's hard to get the 3, 4, 5 people together for it. But so those games I list, I enjoy those. I'm currently playing The Crew. I highly recommend The Crew. For anyone who knows trick-taking games like Spades, imagine tactical trick-taking games with a little bit of theming going on. That's The Crew. Outrageously good. What about you, Jeff?
I'm going to highly recommend you join boardgamearena.com. It's a website. It's free that lets you play many of these games. My favorite on there right now is St. Petersburg. And it's fantastic. By the way, the Venn diagram of strategic games and appellate lawyers, there's got to be a lot of overlap. Tim, we got to get boardgamearena.com to be a sponsor of the program.
There you go.
But yeah, boardgamearena.com and St. Petersburg. My wife kicked the crap out of me last night. 3 of those, 3 games in a row on that game.
Okay, and yes, we'll bookmark that for possible sponsorship next season. And Jeff, you have you mentioned your son. You have an adopted son, and you are passionate about foster care and adoption. Can you tell us more about that?
Yeah, my wife and I have an interesting story in that adoption was our plan A. We started talking about adoption while we were dating pretty early on. And it was something that neither of us had really thought about too much before that, but it just really grabbed us. We adopted our son from Thailand. He's 7 now. He was 2 when we adopted him. He's thriving. He's happy. And we're of the view that out of all of the good you can do in the world, I mean, one of the really great ways you can do good is by bringing a child who needs a family into your family. There's so many programs out there that are for feeding those who need food and sheltering those who need shelter. One of the things that makes a person vulnerable in need of all of these interventions from the outside and supports from the outside can be the fact that they didn't grow up with a family. And so that was something that grabbed us. We thought about what good can we do in the world, and we saw it through adoption. And we also really enjoy being parents. That works really well too. And so that's our story, how we came to it. I am on a board that it's called, I'll give them a shout out, the Real Hope Project. They make reels, REEL, that allow families, people who might be foster parents, to see what the real story or what the human story of children in foster care is. You have plenty of information in the water and on the internet about how children who grow up in foster care can experience really hard things and come with really challenging problems. What you don't see there is that there are also human beings that enjoy dinosaurs and Slurpees and skateboards and cartoons and all of those things. And it's not that those things make the challenges of adopting or fostering a child out of the foster care system any easier, or adopting out of the foster care system, but it does. It allows you to see that these are people, and I think we're doing a plenty good job of telling people that kids who are in foster care and adopting out of foster care have challenges. And I don't think we necessarily do a good job of saying, but they're also children and they're delights. And you should have the whole story, not just the worst case scenario story when you're making those decisions. So Real Hope Project makes these reels for these kids, and they do it in Minnesota. They're spreading around other places, and it's really good work. My wife is also on the board for a separate adoption organization in the state of Minnesota. This is something we care about very much.
Yeah, I love that story. That was, and not to, I don't know, not to make a judgment or anything, but I love that it was that was your first plan. That was your plan A, not a backup plan.
It's fine for people to come to it second, as often people come to adoption or foster care second. They want to make a baby the old-fashioned way, which is totally fine. But there's a lot of need out there. There's a lot of need in country in the United States adopting out of the foster care system, and there's a lot of need elsewhere with just children who, fortunately, there are places like Thailand that don't have institutional care. They have a wonderful foster care network, but that's still only temporary. And that's the reason we looked internationally. It's just that we didn't feel qualified, at least at the time, to adopt out of foster care, and that's where the need seemed to be in the U.S. And we went there. So it's no problem if it's not someone's first plan, but I wouldn't mind a world in which, when people are falling in love and talking about creating families, that adoption was put on the same level as the old-fashioned way of doing it, just as part of a discussion, and not the second place you get. But it's still wonderful. However people come to it, I very strongly believe that adoption and foster care should be a big tent movement, and not saying you have to believe the right things to participate in the good work that you can do here.
Yeah, I love that. Yeah, thank you for that example. All right, so we've talked a little bit about your the big picture of your practice and some personal the hobbies and your family life. Now let's I just want to do a quick kind of lightning round on your on legal practice issues, and then we're going to jump into the state comparative law study here. So, okay, so Jeff, would you rather be in state court or in federal court?
District court, federal. For appellate work, I could go either. I find state court a bit more cozy. I clerked at the Minnesota Court of Appeals for more than 2 years. I'm there more frequently. I find it a comfortable place. I feel I like it there. So I could go either way, but maybe slight preference for Minnesota appellate courts.
Got it. Would you rather be in your state court system? Is it appellant and respondent, or is it appellant and appellee?
Appellate and respondent.
Okay, that's like in California. So far, I think we're in the minority. Everyone else calls it the appellee. Would you rather be the appellant or the respondent?
I saw that question. You sent it to me earlier, and I thought about it. You know, if I want to win, respondent. It's easier to win as the respondent, even if it's a legal issue and it's de novo review. Someone's already agreed with you. But the fun of it, I think being the appellant is way more fun. You're trying to turn a no into a yes or a yes into a no. I think the fun of the work is there. I enjoy both sides, but it's a little bit harder on the appellant side, and I like that challenge.
What do you think your clients or opposing counsel would say is unique about your legal practice or your approach to your practice?
I'm a pretty jovial guy, even in the midst of challenging situations. I like to believe the people I work with, including adverse lawyers who by definition were adverse, I like to think that they think of me as a pretty jovial guy. This job is hard enough. The work is hard enough. Not to add to it that you're going to be hostile without reason. So I make it a point to try to be civil and more than civil, jovial, and I hope other people think that way too. Think that too.
Well, I have to say it does come through, Jeff. So I think people would pick that up from dealing with you. That's a good way to be. I've enjoyed our conversation so far. Jeff, do you have a good a war story that you like to tell, or maybe a trap that you commonly advise trial attorneys to avoid?
I would say two, one appellate and one preserving issues. Appellate, in Minnesota, we have a strict jurisdictional rule for serving the notice of appeal to get your appeal started. I know other jurisdictions have things like that. And it can get a little dicey with multi-party appeals. Occasionally you see some poor appellant who only served one of the other parties, possibly based on a view that the other party didn't really matter. They maybe didn't participate a lot in the litigation, or you're not really adverse to them, even though you are technically adverse, and it can impact the scope of appellate review. So the very straightforward tip I say is just serve everyone. Just serve them all. If they want to come, if they're going to participate in response to it, they could have been a problem for you if you didn't serve them, because you can really mess with your appeal before it gets started if you don't. As for the
before you jump off on that, so you're saying that an appellant can file a timely notice of appeal, identify the correct order, it's filed timely and everything, but if you don't serve all of the right respondents, that could constitute a jurisdictional defect in your notice of appeal?
Yeah, if the issues that or if the issues are inextricably intertwined between the two parties. If there's a way to sever the appeal, then sure, we can do that and say that you can still proceed with your appeal as to the one you served, but not the one you did not. But if you can't change the judgment as to served defendant or served respondent without changing it as to the not served one, you have a big problem, and our appellate courts are pretty strict with that jurisdictional deadline.
Yeah. And then what was the other tip or trap that you give to trial attorneys about? I think it was about preservation of issues.
This is my pitch also for having an appellate lawyer with you at trials too. Preserve, even if you know the judge is going to disagree.
But the judge is going to overrule it anyway. The judge is just going to get mad at me.
You say the magic words, "I just want to make my record for appeal." Your judge, I get it. I hear you said that. I'd like to make my record for appeal. And they'll sit back, usually, I think, and then let you do it. And then you go forward and you've made your record for appeal. You make your request. The judge says still no. All right. That's all we had to do here. Moving on to the hills I might win on here to avoid an appeal entirely.
There you go.
Yeah.
What is What is your favorite part of practice? Other than I think the answer is the same for all appellate attorneys. It's writing. We get into the business because we love drafting briefs.
Yeah.
So I'm going to make it harder and say, other than drafting briefs, what's your favorite part of appellate practice?
The conversation at oral argument. It's so much fun when you have the more complex, the better. Of an issue that you've done your job, you have sophisticated counsel on the other side, everyone's done a good job, and you have just a really great elevated discussion with an appellate panel trying to figure out what's right. I think that's just so much fun, and I would say also a part of it, unlocking that point that should be the first thing you say at oral argument. Some appellate courts give you a few free minutes to chat, to talk before they'll interrupt you with questions. Some of them don't. But the chances are you have at least 15 seconds, maybe 30, where you're going to get to talk uninterrupted. Discovering that point that is worth saying first, if you get to say nothing else you're choosing to say for the rest of that time, I think that's really fun to get there. And then the discussion that goes from there. I think that's a really fun process.
I think that's a really great point. It reminds me of something that we talked with another guest a year or so ago, Myron Moskowitz. He's a very prominent appellate attorney here in California. And we were talking on the subject of oral argument. And I think I asked him something on to the effect of, when should you be preparing for oral argument? And he says, I think his answer was, at the time you're writing your opening brief. If you are only thinking of oral argument when you're writing your reply brief, or certainly later than that, it's too late. You need to have developed that theme, before you start writing your opening brief, or before you file it anyway. What you said about having that 15 to 30 seconds where you're most likely to be uninterrupted, you should have that. That should be your theme of the case throughout your briefing.
I completely agree. This is something I've been thinking about particularly recently, about how the introduction to a brief is in the same ballpark as the oral argument introduction, finding that theme. Once upon a time in some earlier briefs, I would spend my introduction a little bit too much on a roadmap. I don't think you really need a roadmap for introductions necessarily. If you have good headings and you have a table of contents that's a roadmap, I think that there's some play there where you don't just need like if you have 5 points that are coming in your brief, just to say what the 5 points are, just in that order. I think that there's some art to it where you can find a theme and find a very maybe colloquial, plain English way to say the gist of what's coming, and not bother with the point by point. Here's what's coming. I'm not against roadmaps per se, but as someone who I think has over roadmapped in the past, I think seeing cases where it's just, you don't need to say that. The introduction says enough that the reader knows what's coming, that you don't just need to copy paste Roman numerals 1 through 5 headings into your introduction. You had the table of contents, you had your statement of the issues, at least in Minnesota state appellate courts, where you're saying what the issues and what your view is there. I think you can there could be a lot of value from just getting right to the heart of it, like you do at an oral argument during those first 30 seconds, with what's the first thing you want the panel to hear? What's the chorus for the song you're about to sing for the next several pages? Yeah.
I love how you offered that you're someone who in the past has over roadmapped your briefs. That helps it helps me sympathize with your point a little bit. It reminds me of when I talk with Jeff Lewis about one space versus two spaces. I used to be an ardent defender of two spacing, and so now I'm a one spacer, but I have a little bit of sympathy for the two spacers still. Okay. Well, let's. Oh, okay. Well, and then I asked you what was your favorite thing about appellate practice other than briefing, but on the topic of briefing, do you have another briefing or writing tip? You talked about the introduction, so I think that could probably serve. But if you have another briefing or writing tip you'd like to pass on to our audience.
Print it. Print the brief. Yeah. I don't do it all the time, and I want to start doing it more. And when I do it, there's just some way that the eyes change. The feel of it changes when you see the page in front of you. I would say printing the thing and reading it at least once before you click finalize, in paper form. But I would say the other one is really don't overlook and waste the introduction. I would circle back to that. I would just look. Don't try to force the introduction before at the very beginning. Look for that thing that unlocks the whole brief, and that's worth saying first. The thing that you would say during your elevator speech to someone about what's the case about. I think there's value to getting that into an introduction. And if your introduction is longer than a page, you've probably done something wrong. I've had introductions that have been longer than a page. I know sometimes you have cases that maybe warrant that. The shorter, the better, and a very strong presumption against more than a one-page introduction. Even if you haven't touched on everything, touch on the essentials, because the more you write, the less it's going to actually have the effect that you're going for.
Okay. All right. Well, Jeff Markowitz, I want to ask you now, we're going to move on to business here, and we're going to continue our study of comparing and contrasting California with other state civil procedure and appellate procedure. Now, Jeff and I sometimes like to get up on our soapbox, especially me. I'm usually mostly up on the soapbox, complaining about things that I dislike about California's appellate procedure or civil procedure, most commonly about the no citation rule, that we can't publish to unpublished opinions. But then we thought maybe we should just hold our tongues a little bit, or I should hold my tongue and see maybe we have a pretty good thing here in California. Maybe other states have problems of their own. Maybe they have some things that are better, maybe some worse. Maybe we can start up a dialogue here, a cross-jurisdictional dialogue, and see what's working in our respective states and what's not working, and see if we can kind of cross-pollinate good ideas and who knows, maybe in the end weed out some bad ideas. So I'm going to go through a list here that I've developed just kind of on the fly. Jeff and I during this podcast have talked about various issues. So here's the first question I wanted to ask you about. In your state, in Minnesota, or if you, since you can stand in as a representative for North Dakota, since you've appeared in the Supreme Court there, and Wisconsin, I believe, as well. Who sets the rules of civil procedure in your state, or in the jurisdictions where you practice? Is it the legislature or the Supreme Court of the state?
In Minnesota, it's the Supreme Court, which I think works very well. In Wisconsin, they have statutes. I don't know to what role the judiciary is informing the statutes, but they have the appellate rules are generally in statutes, not court rules. In North Dakota, I don't know. I don't know. I think they might also be a statute state, but I'm iffy there. I'm certain about the Minnesota piece, though.
Okay. Yeah, and maybe we should stick with Minnesota rather than have you answer for 3 different states. That's unfair.
Yeah. Objection, compound.
Exactly.
Yeah.
Okay. Well, and that is that's our first difference, because in California, the legislature promulgates the Code of Civil Procedure here. There's a judicial council, which is under the Supreme Court, which promulgates rules of court, which may supplement or gap fill in the Code of Civil Procedure, but may not conflict with any of the with any of the statutes of civil procedure. And so I understand that California is in a minority. We follow the federal model, where Congress has promulgated the federal rules of civil procedure, but in most states it is the judiciary, it sounds like. In your state, in Minnesota, do the courts provide court reporters in all of your departments?
Yes.
So whenever you go into really any kind of proceeding, there's already going to be a court reporter ready and waiting to go?
It's in the water. I think so. I've never had to think about it. If there's a deposition, we have to hire our court reporters, but there's no judge there. But when you're going into court, there's a court reporter.
Imagine a world where you have a client of modest means, you have an important hearing coming up, like a summary judgment or an anti-SLAPP, and you have to make the decision, do we spend the money to bring in an outside court reporter? Because if we don't, maybe some of our arguments might be limited on appeal. That's the world of Los Angeles and Orange County, California.
Wow.
Yeah, there is a national court reporter shortage. For whatever reason, I haven't been able to put my thumb exactly on the reason, but for the past 3 decades, there have been more court reporters retiring than taking up the profession. It is a relatively well-paid and interesting profession, and yet there's just not enough new entrants into the profession, and so it is getting harder and harder to find them. So in California here, in the Los Angeles Superior Court, for example, the largest superior court in the state, the probate and family law departments now were the last holdouts where the court was still providing them, and now they can no longer provide them because of the shortage, and they had to be reallocated to juvenile departments. So that is a problem, partly because there is not a way of electronically recording the proceedings for use of creating an oral record. So that was my other question. It sounds like if you always have court reporters at your proceedings, do you know if there is another means of creating an oral record, or does it just never come up?
It doesn't come up. When you appeal, the state of Minnesota's got a pretty straightforward process. You appeal, you get it all running. Eventually, the district court or the body you're appealing from sends the record up to the Court of Appeals, and you as the appellant, if you want review of an issue that depends on something that happened orally at a hearing, have the duty to order the transcripts from the court reporter, and your appellate timeline doesn't start until the delivery of those transcripts. But that's a pretty straightforward process. Yeah. You're not supplying the court reporter. I know there's a rule for what do you do when the record's incomplete. You can have an agreed upon record between the parties.
Yeah,
I know it's there. I have never needed it. I don't think I've ever seen it used.
Okay. Let's see. Let's move on to the topic of stare decisis. Now, in California, we've talked about on the podcast, there is no horizontal stare decisis. We have 6 district courts of appeal. There are 6 districts in the Court of Appeal, and if District 1 issues an opinion on Monday and District 2 issues an opinion on the same point of law on Tuesday, it can completely ignore the first district. And for that matter, if first district issues another opinion on Wednesday on the same point of law, it can ignore what it said on Monday. Is that the same or different in Minnesota?
Different. I'll start with the caveat before I criticize the practice that I get part of the problem. Minnesota's got a unified intermediary appellate court. California's got the 4 divisions. New York, I think, has 4 departments. The larger states that have all of that appellate work, all of those appeals, I recognize are in a different situation. But my gosh, that sounds like a mixture between a kind of a chaotic way to do things, an expensive way to do things, and relatedly a lawyer's employment act to do things, because you don't have it takes so long to get finality. Only if someone climbs to the California Supreme Court can you actually definitively resolve something. Do you find that the California Supreme Court has a reasonably predictable and prompt turnaround for opinions?
I would say no. What about you, Jeff? I mean,
I don't know about reasonable, predictable. The interesting thing about our California Supreme Court is they are the decisions are frequently unanimous or not evenly divided, and I'm very rarely surprised by what comes out of the Supreme Court. That's my perspective.
So, Jeff, in Minnesota, is your unified court of appeal more like does the stare decisis work more like the circuit courts of appeal, where one panel's decision is binding on the others unless it's taken up en banc? Then that is the rule on that circuit.
Yes, exactly. Exactly what you said. If the Court of Appeals issues an opinion in a precedential form, a published opinion, then that's a precedential opinion, and subsequent appellate panels of the court are bound by it. And although we speak in terms of panels, the court is one court. When a panel releases an opinion authored by one of the judges and signed on to by the other 2, that's the opinion of the court. If it's a precedential opinion, it is the precedential opinion of the court. If it's a non-precedential opinion, same way.
Yeah. That's so for listeners who might be kind of bogged down in all this minutia here. The practical takeaway is that in California, if you're drafting an argument on appeal and you're tempted to say the binding precedent of the Court of Appeal says, take out the word binding. There's nothing is binding in the Court of Appeal. It's binding on superior courts, but nothing that one Court of Appeal says is binding on any other Court of Appeal. It's only the Supreme Court that's binding on the courts of appeal. But it's very different in the circuit courts of appeal and in the Minnesota State Court, where there is horizontal stare decisis. I will say just one word, in favor of it. There's pros and cons. We talked about the cons. It does, is kind of chaotic and frustrating sometimes. But the pro is that I think it allows different views to flourish within the state. So the California Supreme Court can kind of wait around and see, well, okay, we have this district has gone down this road. Let's see if another district takes up the other view, and then it can. It's the same way the United States Supreme Court will look and see how the different circuit courts of appeal will maybe promulgate different theories on the same point of law, and then the Supreme Court can be the tiebreaker.
Yeah, and I echo back to the situation with a state as large as California, states like in New York. Or, I recognize there could be maybe even issues of representation that you feel like there's with a state so large. Are your divisions geographically limited in scope?
Yeah, they're geographic, and we have, very diverse areas of California. You've got the rural and semi-rural areas and urban areas, and
but they're not limited in scope. They're not limited. I mean, the opinions of the first district up in Sacramento are binding all the way down to San Diego, and the San Diego Superior Court is not especially bound by the 4th District Division 1 down there. It can, if there are two different points of law represented by two different district courts of appeal, then under the Supreme Court decision in auto equity sales, a Superior Court can choose which one to follow, and it doesn't have to be the one that is right down the street from it. It can follow the one that's 1,000 miles away. I
was wondering about I guess this goes to a more fundamental question. How are judges chosen for the different divisions? So in Minnesota, we have an appointment followed by election process. So judges are generally appointed in the first instance to our appellate courts, and then they have to stand for election after a certain period of time. And that's partially a function of judges have a custom of stepping down during their term, and the governor will appoint someone from recommended from a group recommended from a advisory panel that's appointed. But so there's no elections in the first place. We don't have a very heavy judicial election world. There are judicial elections, but by and large, almost every single time, the judges in the first instance appointed by the governor based on a group that's been recommended, and then they stand for election, or often the incumbent is unopposed and reelected.
Yeah, I say that is roughly the same as in California, and I think like in Minnesota, far and away, the judges initially come into their office by appointment rather than election.
And are they geographically drawn? Are the seats geographically limited to certain regions, or are they at-large positions statewide? So in Minnesota, we have some positions on our Court of Appeals that have to be drawn from a particular judicial district of the state, and others that can be filled from anyone throughout the state.
I don't know the answer to that question, Jeff. I
don't think we have similar requirements here.
Sure.
Yeah, I don't think there's a requirement. I think as a practical matter, as far as I've noticed, they usually come from the same geographical region.
Sure.
But I don't know that there's a limitation on it.
Sure.
Okay, let's move on. So we've talked about the question of stare decisis. Are the opinions of one district in Minnesota binding on another? And in general, yes, they are. They follow the Circuit Court of Appeals format, where there is horizontal stare decisis. That is a difference from the California system, where there is no horizontal stare decisis. It's the wild, wild west out here. The first district does not have to follow what any of the other districts say, and vice versa. On a similar topic, let me ask you about the practice of not publishing opinions. So when the Court of Appeal issues an opinion and stamps "not published" on the front of it, in California, that means that not only is it not published, it's not going to be put into those nice bound volumes that appear as decoration on an attorney or a judge's wall that no one is ever going to go reference. It's just going to collect dust because everyone's going to case text anyway to find their legal research. Not only is it not physically published, but in California you cannot cite it. You have to when you see that unpublished case, you have to promptly forget about it and never even think about citing it to a judge anywhere here in California. What happens in Minnesota? What is the effect of an opinion that is not published? Does it have any value? Can you cite to it? Is it just non-binding?
You can cite to it. It is not binding. You may cite to it for its precedential value, but because it's not binding, you need to prove your point with it. You need to rally an argument. So you might say, in the only time that this court or any has ever addressed the issue, it said X, and that has some value. And you might say this court has issued inconsistent opinions in its non-precedential ones. The more persuasive one is Y. Or you might say that this court has addressed this issue before, and you should follow that court for the following reason. And I think that really threads the needle nicely. This used to be something done by case law, and through some recent amendments to our appellate rules, it's now codified in the rules. And I think that makes sense. When the court thinks it's issuing, when the Court of Appeals from Minnesota thinks it's issuing a new point of law that meets this criteria that's codified of considerations that for publication, we call it now presidential opinion issuing, but publication, then they'll publish. And if they don't, they don't. But just because they don't doesn't mean it's anathema to ever mention it again. It's sort of like we don't talk about Bruno. It's I see
the Disney movie. What is that? The Disney movie? I forget the name of it now. My kids
Encanto. Yeah.
Encanto. Yeah.
It has some value. Now, again, I would be open to hearing from the perspective of jurists who are in such a large state as California that have so much litigation just because of its size and 4 different divisions or departments of their appellate court. I'd be open to hearing arguments for why you need that rule, but I would be really skeptical that you should never, ever, ever, never cite these. There's just so little value. The world's going to fall down if you can put in your brief that some judges on the California Court of Appeals have once said X. It seems like you're missing some value there, even if it's only a tiny bit of value.
Yeah. No, we don't talk about Bruno here in California. We've well, this is a soapbox I've gotten on before, but so in Minnesota seems to follow the Circuit Court of Appeals approach, where it's just non-binding. We've noticed, Jeff and I have noticed here in the Ninth Circuit, that although you can cite and quote from memorandum opinions or unpublished opinions to the Ninth Circuit, the Ninth Circuit sometimes will indicate fairly explicitly that they don't like it. They'll say, counsel, that opinion's not published, so please don't cite it to us. Now again, I'm reminded of something that we had Justice James Lambden, formerly on the First District Court of Appeal here in California, and his take on this was interesting. It was that, well, look, the question is just finding a persuasive argument. So if you can find that persuasive argument in a binding opinion or in a non-binding opinion, it's all just his point was limited to in California, where we don't have any binding opinions anyway. So it doesn't much matter if it's published, because even if it was published, it's still not binding, right? So the only thing that's binding is if you can find something that persuades the mind. So that's the trick, is not saying, aha, I found some argument, you have to accept it. Like no appellate justice in California has to accept anything except what you can persuade a fair mind to accept.
I take that point. I think I would add to it that there's the cloud of witnesses principle, where you say it's not a reasoned argument. That's not, the reasoned argument is over here. That's the main event. But we also say at least one judge or 3 judges or 2 or 3 panels have agreed with this position before. it doesn't, I think it's more on the front end of the mental process and not on the back, where you're a lawyer, you're writing arguments, judges are tired, they're just like, oh, a lawyer's got another argument. It wakes up the mind just a little bit to say, your colleagues 6 years ago said the same thing. It's not that it's part of the argument. You don't say, and so and such said it. It's like, no, the statute means what the statute means. But if you've got colleagues who have heard arguments and come out one way some years prior, it wakes up the mind just a little bit as the process for busy lawyers trying to get busy judges to track their arguments. I think there's some value there.
Yeah. All right. Well, we're coming up close to an hour. I did have a few more issues I wanted to ask you about, though. Here's a quick one. In written opinions in California, one of the things that we're thankful for here is we have a constitutional right to a reasoned opinion on appeal. So once you have a cause, then the disposition of it, whether it's reverse or affirm, the parties are entitled to a reasoned opinion. So no summary affirmances here, except in the rare exception. What happens in Minnesota? Do you get a reasoned opinion all the time, or are there summary affirmances?
With a qualifier that sometimes you feel like an argument that you made doesn't get quite the attention you wanted it to. We get rationales. There are sometimes in the workers' compensation arena, we have a separate appellate system for our Workers' Compensation Court of Appeals, and you have a right to review from the the Minnesota Supreme Court. Sometimes there'll be a summary affirmance. That's the only context I've seen it. In all other situations at the Court of Appeals and at our state Supreme Court, you get a reasoned opinion. I don't think it's a constitutional right. There's a statute for the Minnesota Supreme Court that says you need to issue a written opinion. Our Court of Appeals one says you don't, but the way that's been understood is that it means you can issue order opinions, but even order opinions have rationales. They're just a bit shorter. So I would say it's kind of it's not broke, so we don't need to fix it situation. I don't think we would need a constitutional amendment because maybe that would just spark more controversy. We have lengthy reasoned opinions, even if we disagree with them at the end of the day. And one thing that did that was our Minnesota Court of Appeals was created roughly 40 years, early 1930s. We just celebrated the 40th birthday of the court. And the reason for its creation was our Minnesota Supreme Court was backlogged. Our Court of Appeals was created to stop the backlog. And I think that you see in the earlier days, the Court of Appeals opinions are a bit more abbreviated. I think they were trying to work through the backlog. Yeah. But once you get past the 1980s, you see, lengthier opinions. And now non-presidential opinions are often, I would say, just as thought or reasoned and elaborate as the presidential ones. I've never thought there's just you deprived anyone of a right to tell us what you meant.
Yeah. Here is a question that you brought to my mind. I haven't asked this of our previous guests before. The question is the difference between issues and arguments. So in some jurisdictions, and I think this may be true in Minnesota, litigants may raise new arguments on appeal so long as counsel at trial preserved the issue. In California, I did a quick dive into this. I wasn't able to find any cases that develop a distinction between issues and arguments, but I understand the concept. Is this a recognized distinction in Minnesota, the difference between issues and arguments?
Basically, yes, a little bit. It doesn't come up a lot. There's a developed line of case law in Utah, from the Utah appellate courts, which I think makes a lot of sense. They're the only ones who I've seen really flesh that out. But there is some case law in Minnesota, which I found after seeing what Utah's done to say, arguments are different from issues. It doesn't quite, go into the big, long explanation that the Utah courts have. But if you an argument is in support of an issue, if the issue is what does the statute mean, you argued it means X because of Y or 1 and 2, you can still argue it means X because of 3 and 4 on appeal. I think that makes sense. And I suspect that's what lots of courts just do without drawing the distinction. If you go on to say that the statute is unconstitutional, or you should apply the constitutional avoidance doctrine and not construe it that way because it otherwise would be unconstitutional, I think there you creep from arguments into issues. There are I think I saw Utah courts have been, recognizing there can be a little bit of dancing on the head of a pin distinctions here, but I do think it can be valuable sometimes when you're trying to figure out, do we have a forfeiture issue here, or is this just the development of the argument becoming more mature? on appeal. So I went from thinking we really need that in Minnesota, more talk, and now I'm not so sure about it. I go back and forth.
Okay.
Yeah.
Now, I also wanted to ask you about bonds and stays after a judgment's been entered, and you're happily, you filed your notice of appeal and happily briefing away, and then suddenly, your appellant gets served with a judgment debtor examination, or his bank accounts get seized on. Is there an automatic stay of enforcement of judgment in Minnesota after filing of a notice of appeal? Is there something else you have to do to effect a stay?
No, you, by some local court rules, or general rules of practice, you get 30 days before entry of judgment. There's a stay of entry. So the collection can't just start the day after judgment is entered on an adverse verdict. This gives you some breathing room. But then, absent action of the court, and actually even then, sometimes judges fail to do that. They forget about it, but you draw it to their attention and they'll fix it. But absent that, no, there's no automatic stay of execution of a money judgment pending appeal. And so if you're defending anyone who might have a money judgment against them, you want to be ready with your bond providers to say, okay, here's who we're going to go to and apply to. There's only so much pre-work you can do. They need the judgment amount, but you want to be ready. And you want to know
what is the amount that's required to effect the stay?
Oh, it varies. It has to be adequate security. So it could be a supersedious
set by court order.
Yes, or stipulation of the parties approved by the court. So sometimes it's a supersedious bond, an appeal bond. Sometimes it's a letter of credit that has to be extended periodically. But it has to be adequate security as approved by the court.
And in California, it's similar. You have to get a bond to stay enforcement of a money judgment, but there's an exception. There's a whole nest of exceptions and exceptions to exceptions.
Yeah.
But in general, cost awards, if you have a judgment purely for cost awards, that is not considered to be a money judgment, and so those are automatically stayed on appeal. Is that the same or different in Minnesota?
That's a great question. I don't know the answer to that. I wouldn't be surprised if it's different, because it seems so silly, right? To require someone to run out and get a letter of credit or or something like that. So I don't know the answer to that. I think it makes sense for those to be treated differently. I don't know offhand how Minnesota treats them. All
right. I wanted to ask you at least one question about oral argument. Are there in California? Maybe I'll just give you an option. I'll tell you a few things about California oral argument. Some districts, District Court of Appeals here, are starting to offer tentative opinions. Only a couple of them are doing that. The more common trend seems to be to issue focus letters, where the Court of Appeal will issue a letter telling counsel, look, we're interested in hearing more about issue X, Y, or Z. So please be prepared to discuss that. Anything similar happening in Minnesota? Or are there any other unusual? Do you have and also maybe talk about, do you have a right to oral argument in Minnesota? In California, we do have a right, contrary to the federal practice where it's only by invitation. In California, you have a constitutional right to oral argument.
So we don't do focus letters. I've never seen one at the appellate level. I think I've heard of them at the district court level, the trial level, a little bit, but it's heard from a friend of a friend sort of thing. I've never received one myself. We don't do them at the appellate level. They might not be that bad of an idea. Sometimes there'll be a supplemental briefing order if the appellate court thinks that there's an issue that was not briefed, but perhaps properly before the court, or the court wants to reach it sua sponte, and they sometimes at least let you know that if by supplemental briefing order, but not always. I don't think there's any fixed standard the outside world knows about that governs that, but not focus memos. Do we have a right to oral argument? I don't think so. We have a custom to oral that says you generally get oral arguments, and that's a really strongly followed custom at the appellate level, certainly at the Minnesota Supreme Court, and at the Court of Appeals. As long as you're represented by counsel, you have a right to oral argument. At least it's treated as a right. If you ask for it, you get it. Same with a criminal. If you ask for it, you get it. You'll see sometimes criminal lawyers will say, I don't really want it. I'm okay with the non-oral calendar.
Are you telling me that improper parties are not allowed to have oral argument in the Court of Appeal?
That is the practice of the court.
Interesting.
Unless you have a lawyer, you don't get to. District court, you get to, but not on appeal.
All right. Interesting.
I think it's probably the same at the Minnesota Supreme Court, but it just doesn't come up. I have never heard of a pro se party getting up to the Supreme Court without any lawyer there. Perhaps when they get their petition granted, a lawyer shows up and says, "Okay, I'm interested. Let's go."
What do you think, Jeff? Does that sound like unlawful discrimination between the represented and the non?
It's counterintuitive, but then again, I'm of the view that oral argument, there's not a whole lot of value there, so I'm not sure there's a whole lot of loss to an improper party. Yeah. By the way, while we're on the subject of tenant rulings, I meant to tell you, Tim, last week I was in the Court of Appeal, Second Appellate District Division 4, and could barely get my appearance onto the record when they verbally, the good news, verbally announced their tentative ruling. Bad news was it was against me. But boy, was my argument laser focused during that argument.
Wow. They gave it to you right as you were making your appearance?
Yeah, I just gotten the words out of my mouth. You know, I'd like to reserve 3 minutes for rebuttal. And they said, yeah, but here's our tentative.
They really gave you no opportunity to prepare for that, did they?
No, but I appreciated it. Look, I knew which issue to focus on.
Yeah. Interesting. Okay.
How much time do you get at oral argument?
Well, you know, you get up to 30 minutes. Okay. But what they do is they discourage you from taking that full 30 minutes by ranking or ordering the calendar in terms of time estimates from shortest to the longest. Typically, I estimate as an appellant, 10 minutes or 9 minutes if I want to get under all the other 10-minute people. Because really, if you haven't said it in the first 9 minutes, what else is there to say?
Right. Okay. All right. Well, Jeff, thank you for giving me those answers about Minnesota, the differences in Minnesota civil and appellate procedure. Now I'm going to hand you off to Jeff Lewis, who's going to take you through the painful lightning round procedure. And I'm going to be marking down your answers. If you answer correctly, then you'll get one of these handsome mugs. But be mindful of your answer.
If he's incorrect, we'll send him a broken mug. Before we go to lightning round, one bonus cross-jurisdictional question off script, because it's my thing. California has a robust anti-SLAPP law. An anti-SLAPP law is what gives the First Amendment its teeth and allows for quick dismissal of lawsuits. Does Minnesota have an anti-SLAPP law?
With the caveat, it's the lightning round. I did not prepare. We do have one. It is not consistently enforced in federal court. I actually, one of my runs up to the Eighth Circuit was on this issue, but I was supporting a colleague who was much closer with it, and it was about 7 or 8 years ago. So it's around. There may have been some things that really neutered its application, at least in the federal courts. I can't remember a lot, but there was at least one on the books.
Interesting. Okay.
Yeah.
All right. That will not impact your ability to receive a mug. Here we go. This is the time for our patented copyright segment of the show that answers the most pressing questions that vex appellate nerds around the world. The dreaded lightning round. Give us short responses, 1 sentence, 1 word. If you're truly talented, a good appellate lawyer can reduce an answer to 1 word. Here we go. Font preference, Century Schoolbook, Garamond, or something else?
Times New Roman.
That's 3 words. And it's wrong. But we'll take it.
You're not the first. You're not the first to answer Times New Roman.
After a period, 2 spaces or 1?
1.
Correct. Pled or pleaded?
Pled.
When you're doing your major arguments in your appellate brief, not the big picture arguments, but the core arguments, all caps, initial caps, or sentence case?
Sentence.
Sentence. Bold. Very bold. Okay. A new entry into the lightning round. If you're talking about something belonging to Congress, is it Congress with an apostrophe or Congress with apostrophe S?
Apostrophe S.
Congress is. Okay.
Correct answer.
And after major headings in a brief, do you start the new section on a new page or just continue immediately right below?
Next page.
All right.
Wait, maybe I'm not.
Do you immediately go to a new page for each major heading, or do you just continue right below?
I have varied. I've gone back and forth.
All right. And there can't really seriously be debate about this anymore, but I'll ask it anyway. Do you ever use in your briefs the cleaned up signal in the citations?
No.
Correct answer.
Wow.
I think cleaned up cleans up valuable information.
Hey, one more question. This is my ad. Oxford comma or no?
Of course, yes.
Who says no to that? Nobody's going to say no to an Oxford comma.
Well, you know.
We're civilized. It's 2023.
Yeah.
We've had electricity for a really long time. Oxford comma.
Well, I don't know. Look how many people are irregularizing verbs like pled.
All right, Jeff. You survived the dreaded lightning round. Congratulations, and you will receive either a broken or an unbroken mug in the mail.
Woo!
All right. Thank you, Jeff. That's going to do it for this episode. Where's my script here? All right, that's going to do it for this episode. We want to once again thank our sponsor Casetext for sponsoring the episode. We want to remind our guests, our listeners again, if you sign up to Casetext using our patented link, you get a 25% discount. So sign up at casetext.com/CALP. That's casetext.com/CALP.
Yep. And if you have suggestions for future episodes or a contact at boardgamers.com, email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
Thanks again, Jeff Markowitz, and we'll see you next time.
Thank you.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.